Hello and a warm welcome to the EDRM Global Webinar channel. My name is Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's Season 5, Episode 2, called Important eDiscovery Case Law Decisions for February 2025. Our faculty experts are Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars, and slides will be available after the webinar. Kaylee Wallstad, EDRM's Chief Strategy Officer, is here. Can you please tell us what resources are available, Kaylee?
Absolutely, and I am just loving Season 5's kickoff. This is our community's, their favorite monthly series, and I cannot wait every month to learn about the new cases. And we're also loving On 24 with so many more ways for you, our audience, to engage. If you check out your console to the right of the screen, see the question mark icon, and if you click on it, this is where you can type in your questions for today's faculty, and we highly encourage you to do so. The paperclip icon, if you click on that, is for related content. You'll see today's resources carefully curated just for you. An On24 engagement tools description for you to download and help you better engage with the platform. There's also a link to click to subscribe to eDiscovery Today, Doug's blog, and never miss a thing. It's my favorite way to start the day. There's also a link to learn more about the Honorable Judge Peck and how you can engage with him. There also is a link to order your copy of Tom O'Connor's spicy newish book, eDiscovery for the Rest of Us, recently updated in collaboration with EDRM's trusted partner, NextPoint. And Tom, you've got a little edition for that coming out soon, right?
Oh, you've been talking to the NextPoint crew, haven't you?
I might have.
We are working on an appendix to the book that we have tentatively called AI for the Rest of Us. Don't know if that's written in stone or not, but we hope to have that out by the ABA Tech Show, which I believe is the first week of April. But that's very, that's if all the writing gods converge on us and everything gets done in time.
Yeah. Not by legal tech?
No. ABA Tech Show, Brett Burney is a member of the board there. There's a long-standing collaboration between him and NextPoint and the ABA Tech Show. So they're of course located there. So they just felt, for a variety of marketing reasons, it made more sense to do it there. So, but
thanks for the sneak peek, Tom.
This is all hearsay, so take it for what it's worth.
And next, be sure to save your seat for next month's important eDiscovery case law decisions for March, on March 20th. Save your seat. And EDRM needs your insights on a short survey closing this week, put out by our trusted partner, Complex Discovery. It is all about eDiscovery pricing, winter 2025. If you have 5 minutes to give, we would be so grateful. And then up next on EDRM's webinar channel tomorrow, February 26th, 2025, eDiscovery Optimization, Faster Insights with Modern Data Strategies. Be sure to save your seat for that. Speaker bios can be clicked and popped up to learn more about today's faculty. And then just like Zoom, you'll see the smiley face emoji in your console. And if you click on it, you'll see many more reactions that you can click during the webinar, and we highly encourage you to engage with them. We're having a lot of fun with them on this platform. And if you click the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn. Back to you, Mary.
Thanks, Kaylee. And for our listeners, Doug Austin is none other than the editor of eDiscovery Today, a daily blog about eDiscovery, information governance, cybersecurity, data privacy, and artificial intelligence trends, best practices, and case law. Doug is an established eDiscovery thought leader with over 30 years of experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and government clients. Doug has published a daily blog since 2010 and has written numerous articles and white papers, receiving the J.D. Super Reader's Choice Award as a top eDiscovery author and a top cybersecurity author. Doug has presented at numerous webcasts, events, conferences, including Legal Tech New York, ILTACon, Relativity Fest, the University of Florida eDiscovery Conference, the Masters Conference, and many local and regional conferences. Tom O'Connor, the director of the Gulf Coast Legal Technology Center, is a nationally known consultant, speaker, and writer in the area of computerized litigation support systems. Tom's consulting experience is primarily in complex litigation matters where he's worked with firms of all sizes. As a matter of fact, he's outside a courtroom today. He also has been appointed as a technical consultant by various federal and state courts on cases dealing with large amounts of electronic evidence. And as Kaylee said, his most recent edition of his popular book, eDiscovery for the Rest of Us, is going to be updated in time for ABA Tech Show with EDRM's trusted partner, Next Point. And the Honorable Judge Andrew Peck is once again a Band 1 Chambers ranked senior counsel at DLA Paper. Congratulations on this year's award, Judge.
Woo-woo.
Thank you.
And the Honorable Andrew J. Peck served for 23 years as a United States Magistrate Judge for the Southern District of New York. Before his appointment to the bench, Judge Peck was in private practice for 17 years, focusing on commercial and entertainment litigation, including copyright and trademark matters, with extensive trial experience. And at DLA Piper, Judge Peck advises on those copyright and trademark matters, also serves as a resource for the firm and its clients on litigation strategy and eDiscovery issues from a judge's perspective. Judge Peck particularly advises on innovative and efficient solutions to the challenges of information management, both within and outside the litigation context, including cross-border discovery issues. He speaks frequently at conferences concerning eDiscovery issues, and since joining DLA Piper, Judge Peck has been retained to serve as special discovery counsel to clients and law firms and to submit expert reports on eDiscovery issues. And EDRM is exceedingly grateful to all three gentlemen for their service on the EDRM Global Advisory Council. And with that, Doug, I'm turning the baton over to you because I understand we have some cases.
Indeed we do, Mary, and thanks. Welcome, everybody. February case law webinar on the EDRM network. Normally I tell you what types of cases we'll be discussing. As usual, we'll be discussing 6 cases, but you can see the slide there. I will note it's been a light lift for me this month, as 3 of the cases were suggested by Judge Peck. 1 was suggested by Chad Roberts, and 1 was covered by Michael Berman on the EDRM blog. So definitely thanks to them for identifying interesting cases for us to talk about. Of course, we do welcome questions. We'll try to get to as many as we can. And as Kaylee mentioned, we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. Disclaimers are valid in any country, any language, and any time zone, which ties into 3 of our cases this month. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery Today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has nearly 41,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant's the definitive source for eDiscovery case law out there. And with that said, let's get into the cases. The ruling in our first case is unconventional. You'll see what I did there in a moment. Thank you. The case, which was suggested by Judge Peck, involved claims of false advertising and deceptive practices against an Israeli corporation over bots to simulate human players in a gaming platform. And a dispute arose over whether plaintiff must adhere to the Hague Convention to obtain discovery from defendant. Defendant asserted that Israel's data protection laws barred defendant from collecting and transferring a significant portion of the non-public responsive documents and information to the U.S. absent an Israeli court order, and maintained that the Hague Convention was the sole mechanism plaintiff could use to obtain non-public evidence from defendant in this matter. It also argued that Israeli privacy law restricted the collection, review, and transfer of materials containing personal information of its customers and employees, defined broadly to encompass virtually any identifying characteristics of an individual, including an email address. In turn, plaintiff revealed that defendant had refused to even disclose the location of its servers and databases, taking the position that the location was irrelevant. Plaintiff explained that the data in defendant's possession, specifically gameplay logs, tournament information, statistics, source code, including bot codes, and defendant's internal communications acknowledging the presence of bots on its platform, were critical to the litigation. In considering the dispute, New York District Judge Denise Coate stated, "Federal courts may, but are not required to resort to the Hague Convention for conducting foreign discovery. The United States and Israel are both signatories of the Hague Convention, which prescribes certain procedures by which a judicial authority in one contracting state may request evidence located in another contracting state. The Hague Convention procedures are merely a permissive supplement to other means of foreign discovery, not exclusive and mandatory, nor are litigants required to use them as a first resort, because the procedures would in some cases be unduly time-consuming and expensive, as well as less certain to produce needed evidence than direct use of the federal rules." Also, after expert testimony, Judge Coate stated, "Based on these experts' declarations, the court finds that Israeli law does not require that discovery of Israeli companies that are parties to a proceeding before a foreign court, including litigation filed in a U.S. court, use the Hague Convention procedures. The PPL confers protection only on data concerning natural persons, not on data pertaining to corporations." So Judge Coate overruled defendant's objection to producing discoverable materials outside of the Hague Convention. So, Tom, Judge Coate stated that defendant's objection wasn't about producing the materials, but doing so outside of the Hague Convention procedures. Do you think that was the real reason they didn't want to produce them?
Well, I mean, two observations. One, of course, is that they didn't admit for quite some time, and only under, I think, prodding by the court, that the documents were all on servers located inside the EU someplace.
Right.
And you know, they may have been extremely concerned about the conflicts between privacy laws in Europe, the Israeli privacy laws, and any conflicts or issues that might have arisen there. So it may have been that in part. It may have been that there was stuff there that they didn't want to reveal the presence of. Not that parties in civil litigation have ever been known to do that, but that might have been a factor. But I also found interesting, lastly, the judge's statement that you just read, that procedures under the Hague Convention can be, quote, unduly time-consuming and expensive, as well as less certain to produce needed evidence than the direct use of the federal rules, end quote. It may be that they just felt that the Hague Convention was a very nice way to drag things out with a less of a chance of a clear production, and therefore maybe more of a chance of a settlement. So I think there's couple of possibilities here for why they didn't want to do this.
Sure. Yeah. You are on Judge. I mean, Judge Coate used the phrase "not required to resort to the Hague Convention." So certainly, it doesn't
Right.
sound like it's a kind of a something that judges are dying to apply here. So
Right.
so Judge,
Right.
yeah, absolutely. So Judge Peck, do you agree with the ruling by Judge Coate? And are there any circumstances where the Hague Convention procedures could have been applied here, and could the defendant have made a better argument to apply them?
I agree with Judge Coate. Of course, I haven't studied what Israeli law is, so I'm not qualified. But I'm much more cynical than my friend O'Connor here. Look, it's defendant's data. If all they cared about was not violating Israeli law or the GDPR, they could have suggested, if they knew about it, which most lawyers don't, Hague Convention Article 2. Article 1 is the full-blown process. Article 2 allows the U.S. court to appoint a commissioner, and the commissioner in the foreign country then decides what should be produced or shouldn't under the Hague Convention, so it satisfies the GDPR and presumably any Israeli secrecy. It is what the defendant in the Salt River case in front of Judge Campbell, former chair of the Rules Committee, district judge in Arizona, Salt River suggested that that's what they would do because they wanted to comply with U.S. discovery but not get in trouble under the GDPR. And they told the court, and don't worry, we know we'll be able to get the data back through that route in something like 3 months. Unfortunately, for those of us in the eDiscovery community, they settled the damn case before 3 months had passed. So we don't know for sure that they are right, but that is certainly a way to go that they could have done if they were not, as Tom suspected they might, and I suspect even more that they might, if they were not trying to hide something.
Right. Yeah, absolutely. Well, very interesting info there. And certainly, Mary, we're seeing more cases involving a discovery from parties in foreign countries. So what advice do you have for our audience on how to request that discovery?
Well, I can offer the EDRM GDPR's project. They've published guidelines and a sample protective order, and they're also creating some training videos for the judiciary. I'd also recommend having it be an agenda item for the 26F so that you can minimize the data you might need from privacy-enhanced jurisdictions and sequence it so that the foreign data comes last if you're the one producing it, because you may be able to narrow the scope, or find out where you have data already, perhaps in US servers. Those CC lines on email can get you a lot of data. And then lastly, consult with someone who knows not just the law, but the practice in the specific jurisdiction, and develop those relationships with the people in country, and bring technology to bear in country if you can to minimize the data exfiltrating.
Yeah, all great points of advice. And I definitely knew you were going to mention the GDPR guide, which is an excellent guide to check out. So I encourage you all to do that. And we'll move on to the next case. And let's face it, the production in our next case left the plaintiff a bit disoriented. This case, also suggested by Judge Peck, involved claims of faulty design in the vehicle manufactured by defendants after plaintiff's son died in a car accident. The plaintiff noticed depositions pursuant to FRCP Rule 30b-6, and in July 2023, shortly after the last Rule 30b-6 deposition, plaintiff moved to compel discovery, specifically to provide fuller responses to her prior written requests to produce more documents, including English translations of certain documents that are currently in Japanese, and further to submit to additional Rule 30b-6 depositions. After a hearing on the matter, the trial court entered the discovery order directing the Toyota defendants to provide further responses to plaintiff's discovery request, ordering the Toyota defendants to supplement certain requests for production of documents, including providing English translation of Japanese documents that had been produced. After another hearing on the matter, the trial court entered the sanctions order sanctioning the Toyota defendants, finding that they were deemed to have admitted that they were jointly obligated in the design of Mr. Sessome's Scion, that the engine compartment, firewall, and side structure of the Scion were defectively designed and manufactured, that they had constructive notice of these defects, and that a safer alternative design was reasonably available to them. Dang. The Court of Appeals of North Carolina stated, regarding the discovery order and the portions of the sanctions order directing the Toyota defendants to comply with the discovery order, we conclude that the trial court did not abuse its discretion, commit reversible error, or the Toyota defendants have otherwise waived any argument by not timely objecting, except that we conclude the trial court erred by requiring the Toyota defendants to create new documents in English of documents already provided that are in the Japanese language. Rule 26 of our Rules of Civil Procedure allow a party to seek documents in the possession of the adverse party. It does not generally require the adverse party to pay for any said documents to be translated into the English language. Of course, if the Toyota defendants already have English translations of the Japanese language documents in the normal course of their business, or they create English summaries of these documents for any purpose, such documents should be provided as being within the scope of the rule. The appellate court also ruled on the sanctions order, stating, we vacate the sanctions order and remand the matter to the trial court to reconsider its sanctions order by exercising its discretion and fashioning an appropriate sanction if it still deems sanctions to be appropriate. So, Judge Peck, are you surprised that the trial court ordered translation of the documents to be provided, or are you surprised that the North Carolina appellate court reversed the order, that part of the order?
I'll just say that I agree with the appellate court ruling that there's no obligation to translate. And I think that would be the same result under the federal rules. But, I have an interesting question here. The appellate order was, if Toyota comes up with or creates translations in the future, then they need to produce them. If we were in federal court, that would raise the issue under Rule 26E of the duty to supplement one's responses when new information is available. So query if at the time of document production, all they have are the Japanese versions, but somewhere between that production and the summary judgment motion or trial, they have translations made. Do those then have to be produced as a 26E supplementation? The court didn't go into that here. I don't think anyone raised it, but I think it's an interesting question.
That is an interesting question, because that certainly almost seems like maybe it was language, the way it was written was maybe not the way they intended, but who knows what they were thinking there. But yeah, it's a great point. So Mary, given that generative AI platforms can easily translate documents today, isn't the dispute over translation of Japanese documents really pretty much ado about nothing?
I don't know about that, because the AI translations are way better than they used to be, but they're still not perfect. And certainly the receiving party can translate the material using AI as well. But think about that. What platform are they going to use? Would it be insecure? Would they resolve doubts in their favor? So in my experience, most producing parties like to control their productions, and so they may want to translate themselves.
Yeah, sure. That makes perfect sense, that you would want to kind of control how the translation, because it can be translated, different ways. So absolutely. So Tom, the trial court, oh, go ahead.
Sorry, just jumping in there. The other question is, if one used, whether the plaintiff or defendant, an AI translation or any other more informal type of translation tool, would that suffice for any of those documents that a party wanted to admit into evidence, either on the summary judgment motion or at trial? And I'm dubious. I think for that, you would need a quote unquote certified official type translation.
Yeah, great point. Because then you I guess maybe you could use AI to translate to get a sense of whether the documents are important to the case, but then you might have to go the extra step of getting a certified translation for the ones that you might use. So yeah, that's a great point. So Tom, the trial court's finding that the Toyota defendants were deemed to have admitted defects, constructive notice of these defects, and the availability of a safer alternative design seems about as close to a dispositive sanction as you can get without actually terminating the case. Does the proposed punishment fit the crime here?
Well, I think, in reading the decision, you come across the fact that the judge did this because the party had not responded to the discovery order in a timely fashion. So basically, he was deeming them to have admitted everything by their not doing anything. But I think more important, it would seem to me, reading between the lines, they had violated Judge Peck's well-known prescription about how one should not piss off the judge. And so, yeah, no, I don't think it did. You get a discovery order that you just ignore. Man, you do that at your peril, right?
Yeah. I mean, certainly seemed like the appellate court kind of thought the sanctions order was a bit extreme, vacating it and saying, hey, trial court, you should reconsider this. So it seemed pretty intense to me. So
Interestingly, though, in the last sentence there on the screen, they said you could fashion appropriate sanctions if it still deems sanctions to be appropriate, thinking that perhaps this was going to go away now that the judge had gotten the party's attention.
Yeah, always possible. So great point, and an interesting case. So we'll move on to our next case, which is basically a kind of dispute and ESI request that I think we're going to see a lot more of. In this case, involving claims of copyright infringement against Meta over its Llama AI models, the court ordered the parties to file a supplemental letter brief concerning RFP 118, requesting the 4 categories of data you see there in the sub-bullet points, for which plaintiffs sought both the raw original data from which these post-training data sets were created, as well as the data as specifically formed or constituted for use in the aforementioned post-training of the Llama models. California Magistrate Judge Thomas Hickson, who we've covered several of his cases in the past, decided to start with the second category first and stated, the court thinks these data sets are responsive to RFP 118. It's true that RFP 118 did not use the words training data, but it did request all documents and communications, including source code, relating to any efforts, attempts, or measures implemented by Meta to prevent Llama models from emitting or outputting copyrighted material. The requested data sets are certainly documents, and they seem to relate to efforts or attempts by Meta to prevent the Llama models from outputting copyrighted material. The court also thinks plaintiffs have made a sufficient showing of relevance. The Llama 2 and 3 papers make clear that fine-tuning is part of the training process for the Llama models. Here, a big factual dispute between the parties is whether the fine-tuning data consists of the copyrighted works themselves. Plaintiffs strenuously argue that it does, and Meta denies this. So he granted the category of the request for AI training data. Judge Hickson denied the request for the third and fourth categories and granted the first category, but only if it was used to fine-tune one or more Llama models for the intellectual property safety category. He denied plaintiffs' request for the raw original data from which the post-training data sets were created, stating, Section 3.1 of the Llama 2 paper suggests that the raw or original data is not only massive compared to the data sets actually used, but also of dubious value. The court therefore concludes that the raw or original data from which the post-training data sets were created is not proportional to the needs of the case. So Mary, do you see there being a challenge to request for training data in cases like this, where the volume of data that's used to train the model could be huge?
Oh, absolutely. And you can see that they've narrowed the data that needs to be produced or inspected. And speaking of produced or inspected, we have used inspection for very, very large data sets for data warehouses, databases, and things for years. So we do have a way to deal with the large data, but I would anticipate proportionality arguments for all of it.
Indeed, which is a great segue, Mary. It's like you knew what question was coming next to Tom. So Tom, we now have seen a couple of recent cases involving data related to AI models. So what advice do you have for our audience on best practices to keep requests for those materials proportional?
Well, I think the court did a good job of, setting out there's two factors to be considered here. The first is the intellectual property in question, or the proposed violation or the alleged violation. You only have to show that they may have or could have resulted in portions of that copyright work ending up in the fine-tuning data sets. So is there, in fact, a relevance to what's going on? But then when it comes to proportionality, you have to make sure, especially as in this case where there's multiple data sets, right? There's multiple papers and multiple data sets, some of which are, in the court's own words, massive. Are they all of equal value? And does the value of going through that exercise outweigh the size and complexity of the data involved? The classic proportionality analysis, right? So you've got to make sure that it's and the court made sure to point out, he called it, is it a worthwhile endeavor in view of all the factors in Rule 26b1? So I think that's what you got to make sure. You can't just make that allegation, but you got to be able to say that it's going to be worth going through the exercise of dealing with these different data sets, especially the large ones.
Yeah, absolutely. And, it doesn't really, not totally reflected on the slide here, but certainly the case gets into a little bit about how the plaintiffs, I think, focused their request a bit more. And of course, they requested both the raw original data, but then the data that was specifically former constituted. So they provided a couple of different ways to, kind of get to a proportional result there, which I think was smart on their part. For sure. So the question from the audience, yes, just to clarify, these we're talking about the training of Meta's own model, not training of an eDiscovery AI training set. But yeah, it's certainly probably we'll see some cases relating to that coming up, or disputes at least relating to that in the future. But in this case, they're talking about copyright and the model itself. So yeah. So Judge Peck, do you agree with the ruling by Judge Hickson that the raw or original data from which the post-training data sets were created is not proportional to the needs of the case? I mean, isn't the raw or original data used to create the post-training data sets the heart of a case in a copyright infringement case?
Yes, so you've got, relevancy, yeah, probably. Proportionality, probably not. And just based on, what I've read about large language models, probably, scraping everything they could find from the internet and everywhere else. There's probably so much data there that one couldn't possibly get a handle on it. One could say maybe only the raw data that had copyrighted material, but, how is that defined, et cetera, et cetera. So since the secondary training material is available, that's certainly a good happy median of dealing with it. Perhaps one could argue after looking at that you need more, but there's got to be a limit somewhere.
Yeah, for sure. And it's going to be interesting. I expect we'll see more cases like this and how they request the data. Seems like the plaintiffs did a pretty good job here to at least, kind of tailor their request to an extent to get some of that data. So we'll move on to our next case, which was also suggested by Judge Peck. And it was filed by the son of a decedent who died after contracting COVID while in the custody of ICE. There was also a separate class action filed by detainees at an ICE facility challenging their conditions of confinement during the COVID-19 pandemic in the case Roman v. Wolf. After the decedent died here on March 8, 2021, the Department of Homeland Security's OPLA office issued a preservation notice to ICE on March 30 concerning the decedent's death, and 2 days later, plaintiff also sent defendant Geo Group a document preservation letter concerning information related to the decedent's death. Plaintiff counsel and USA's counsel discussed the litigation hold documents related to the Roman case, with parties disagreed over whether USA should be considered a party to that case. Ultimately, the plaintiff filed a motion to compel defendant USA to produce documents responsive to plaintiff's RFPs, including compelling USA to produce any document retention policies and litigation hold notices issued by USA in both this case and the Roman litigation. Regarding USA's contention that plaintiff failed to comply with Local Rule 37's meet and confer requirement prior to filing the instant motion to compel, California Magistrate Judge Sherry Pym stated, "Here the record shows plaintiff did bring up the issue of USA's allegedly deficient response to his RFPs, RFP numbers 22 and 57, in his September 12 meet and confer letter, albeit briefly. Moreover, it does appear that both parties agree they talked about these issues to some degree during their September 23 meet and confer session." She also rejected USA's contention the issue was partially moot because it agreed to produce ICE's document retention policies applicable to video surveillance because there was dispute as to whether USA provided the operative 2020-2021 version of ICE's document retention policies to plaintiff. So she ordered them to confirm they did so or do so immediately. As you can see there, she also rejected USA's argument that it should not be required to produce the requested documents because they relate to another party's litigation hold in another matter. Regarding USA's argument that the litigation hold documents were protected from discovery by the attorney-client privilege, Judge Pym stated, multiple courts in the circuit have held that while the attorney-client privilege protects litigation hold documents, the basic details surrounding the litigation hold are not. So Judge Pym ordered the USA to produce information concerning when and to whom the litigation hold notices were given and what kinds and categories of information and data USA instructed to be preserved and or collected, as well as its document retention policies. Interesting. So Tom, USA was ordered to produce the operative 2020-2021 version of ICE's document retention policies. What information do you think the plaintiff is hoping to get from the production of those policies?
Well, I think the first and foremost, and obvious on its face, is what the judge said, that they're, even though it's different cases, quote, the hold itself could have applied to documents relevant to this case. So the Roman case could have documents that were relevant. So they're looking for new documents. They're looking for something that may not have come up in the one case that did surface in the second case. I would think strategically as well, just what you read towards the end there, they're interested in what the order said with regards to what kinds and categories of information and data USA instructed to be preserved and or collected, as well as the document retention policies. Were they being consistent? Were there any sort of inconsistencies, irregularities, something that if in fact there were documents in one case that applied to another, were deliberately being kept separate as the result of the way each of the litigation holds were fashioned or crafted. And so I would suspect that they were also looking to that.
Yeah, absolutely. Yeah, and obviously retention policies will cover things such as, the length of period retained. So they're looking to see what should be available, prior to that litigation hold being implemented. So definitely interesting to get into both of those. So Judge Peck, do you agree with Judge Pym that the basic details surrounding the litigation hold are not privileged? It seems like kinds and categories of information and data defendants' employees were instructed to preserve and collect would potentially be both attorney-client communications and attorney work product. Am I wrong?
Maybe.
Okay.
It depends. I mean, this is sort of, this issue of, is the litigation hold memo, the piece of paper, or in this day and age, the ESI, is that discoverable? And it's sort of dancing on the head of a pin here. Who got the hold memo and when did they get it? That seems to me to be basic facts. And the court here was right that that's the sort of thing that is discoverable. I mean, in some cases, only if there is some showing of spoliation. In others, just, we need to know who should have been preserving, etc. Now, some other cases differentiate between what the hold memo told the employees to do, and that could be considered attorney-client or work product privilege, but what they did is fair game. Did employee A go out and, put his mobile device on hold? It doesn't matter what the hold memo told them to do, it's what did they do. So there's a little bit of a, dance. You can't have the hold memo, but you can have all this other information. And, an attorney may want to ask him or herself, is the fight worth it?
Mm-hmm. Sure, absolutely. Well, so Mary, another thought that I've had about this is, isn't production of details about the litigation hold considered discovery on discovery, and shouldn't that be reserved for when discovery deficiencies are demonstrated? Your thoughts?
Well, I agree with Judge Peck on this one, and I think it just underscores why keeping court consumable documentation is available is really a very, very good thing. To have your objective data about what people did sequestered from the legal thoughts and impressions and analyses of the attorneys. I think that's what the legal hold systems are all about.
Yeah, absolutely. And certainly interesting kind of resolution to this case. Be interested to see if we get others similar to it in the future.
We will.
So, go ahead. Oh, yes, I'm sure we will. Yeah. So, but this one had a couple of unique nuances that were particularly interesting. Speaking of nuances, our next case was originally covered by Michael Berman on the EDRM blog, and it involves a nuance that many eDiscovery professionals know about, but most legal professionals, and I would say certainly the general public, doesn't know about. In the case, the plaintiff renewed his request for an independent forensic data expert alleging discrepancies in the timestamps of some of the emails produced by defendant Costco as part of the discovery, and Puerto Rico Magistrate Judge Hector Ramos Vega ordered Costco to file an informative motion clarifying the matter, which Costco did, and in it, they clarified that the stamps in the emails that form part of its production of documents are in Coordinated Universal Time, UTC, which is 4 hours ahead of Eastern Standard Time. UTC, Costco further explained, is the time zone in which its eDiscovery experts would extract information, including employee emails. Excuse me. The fact accounted for the discrepancies flagged by the plaintiff where, for example, he claimed he sent an email to Costco submitting his complaint at 6:09 a.m., but the document produced by Costco had a timestamp reflecting 10:09 a.m. Lastly, Costco clarified that timestamps in email threads could vary depending on the sender's location. Makes sense, right? Not to the plaintiff, as Judge Ramos Vega stated, Rivera does not agree with nor accepts this explanation. He continues to be of the view that the discrepancies in the timestamps are part of a scheme by Costco to deceive him and calls into question the accuracy of the documents produced in discovery. Based on that, he's filed the two virtually identical motions that the undersigned is addressing in this section, which requests the appointment of an independent forensic examiner to create a forensic image of defendants' electronic systems and devices after following a 20-item search protocol. More recently, in his renewed opposition, Rivera added a new theory that Costco did not withhold a document, it withheld the timely disclosure of the existence of different time zones for said documents. Rivera contends that the so-called parent emails needed to be rightly identified with the time zone they belong to. After Costco objected to those requests, Judge Ramos Vega stated, "I agree with Costco that the request for the appointment of a forensic computer examiner must be denied because it lacks merit. To obtain the appointment of a neutral expert in computer forensics, plaintiff must offer more than speculation or conjecture. He needs to present at least some reliable information that the opposing party's representations are misleading or substantively inaccurate." Rivera merely speculates that the discrepancy in timestamps must be due to some nefarious intent by Costco, but provides no credible evidence of manipulation or fabrication. At the discovery hearing, Rivera had to admit that the copy of the email generated by him as sender had the correct time of 6:09 a.m., thus confirming Costco's explanation. Not only that, but Judge Ramos Vega also denied two other plaintiffs' motions as moot, and he granted Costco's motion for sanctions in part against plaintiff for misconduct claims, including being belligerent and disrespectful toward counsel and harassing Costco with frivolous motions. Noting that Rivera has also accused the presiding district judge of misconduct and has left several pro bono attorneys appointed by the court with no choice but to move to withdraw due to disagreements with him, Judge Ramos Vega ordered the plaintiff to pay $1,000 to Costco instead of the $12,000 plus that Costco requested. So Judge Peck, the pro se plaintiff's actions, including accusing the presiding district judge of misconduct, seem like a surefire way to invoke your Rule 1.1. Would you have limited the sanction to $1,000 like Judge Ramos Vega did?
I mean, it really is an issue of fairness. I would assume that Mr. Rivera could not pay $12,000. I would be interested to know if he had been granted IFP, informa pauperis status, allowing him to file the case without payment of the, I think it's $350 nowadays, filing fee. If he had been given IFP status, meaning he couldn't afford to pay the $350, he certainly couldn't pay $12,000. Curious whether he could even pay the $1,000. I would just note, and I'm a little surprised here, an easier way for the judge to have decided this case might have been to say, all very nice that you'd like a independent forensic data expert, but we don't have those on staff here at the court, and we don't have any budget to pay such a forensic expert. It's why when the court gave Rivera pro se counsel, it is often done by the court as a courtesy. We can't force an attorney to take this on, but there's enough merit to the case, or enough we would like somebody to be the intervener to keep this plaintiff from bothering us. So one could have done the very simple, no budget for this, sorry, buddy, you're out of luck. Now, yeah, one could have put out a request to the community to, get a Tom O'Connor to see if they'd be willing to serve for free, but that's very, very rarely done. Anytime it's one of these things, it's a call to the bar, you know, we need an attorney here. Is anyone willing to volunteer?
Yeah. Yeah, great point. And yeah, certainly that's and I think, and I didn't include because for space constraints, but Judge Ramos Vega did talk about the importance of not not ordering a forensic examination without due cause and what have you. So certainly would have been an interesting way to go to respond, because he certainly didn't sound like he would have any money to pay for a forensic expert on his own. So one of the things, of course, interesting about this case, Mary, is UTC. So can you talk about why UTC is used for the timestamp in the eDiscovery extraction instead of the time zone of the sender of the email?
Oh, absolutely. And as you said earlier, as you were introducing the case, this is one of those things that people outside of the eDiscovery bubble do not understand. So you can really tell if someone's been around the eDiscovery block a time or two, if they understand this time zone normalization thing. It's not intuitive. So your senders and your receivers can be in many time zones. And one sender who travels can generate mail in many different time zones. So using the UTC is a neutral way to normalize the time of a group of emails sent and received from the different parts of the world or the country, and it allows chronologies, and especially the back and forth on the same day. It allows that to go in order instead of having things interspersed incorrectly in a chronological manner.
Yeah, absolutely. And certainly kind of addresses those situations where, if you think about the time zones and you use those, you literally could send an email from one time zone to an earlier time in another time zone. So, it's one of, when it's being read and what have you. So definitely has become a standard in eDiscovery extraction and processing. And I think it's an interesting case from that standpoint. Good find from Mike Berman there. And definitely one that we've enjoyed talking about. So Tom, hey, we talk about this all the time. Educating lawyers on eDiscovery best practices is tough enough. How are we going to educate potential pro se parties on best practices?
Well, to Mary's point, there's lots of people inside the eDiscovery bubble who don't understand UTC.
Right.
And I've had that sort of discussion trying to explain it to them, and you get that sort of, puppy dog looking to the left, like cocking its head, like, what? Run that by me again? Yeah, and then of course you have pro se, and it makes it more difficult. Well, I think the first way you learn is by, as Mark Twain used to say about grabbing the barbed wire fence. Some people have to learn it the hard way, and apparently the pro se party here did, because he later agreed that he was wrong on the UTC part. But the court can, and this looks tough because this seems like it was a very difficult pro se party. The court tried what Judge Peck just suggested, appointing some attorneys. And it noted that several had no choice but to move to withdraw due to disagreements with him. And then he accused the presiding judge of misconduct. So, dealing with this person, was difficult. I guess the next thing you could do is if the court in question has a source of material. The Northern District for California has a lot of exemplar protocols and explanations of what it wants in certain types of pleadings, and especially with regards to ESI. You can point the party to that. These are public local rules that you should consult and try to familiarize yourself with, and then perhaps point them to more public sources of information other than the courts, like the EDRM or Sedona, and suggest perhaps at one of the early status conferences that they brush up on those. And so, I guess all you can do is suggest, and then if you have a difficult party like you do here, there's not much to be done. It's just tough.
Yeah, unfortunately it is, but certainly an interesting, like I say, nuance, eDiscovery nuance, and an interesting case. So we'll move on to our last case, which involves a dispute over non-privileged documents attached to privileged communications, and it was suggested by Chad Roberts. In this MDL, the plaintiffs contended that the defendants took an incorrect position on when the attorney-client privilege applies to attachments to privileged communications, and asked the court to order the defendants to conduct further reviews of all attachments withheld as privileged. The defendants contended that they had not taken an incorrect position, that no further review of attachments was required, and that this issue was untimely under Case Management Order 19. In response, Arizona District Judge David Campbell, who Judge Peck mentioned earlier, stated, "The court concludes that when a non-privileged document is responsive to a plaintiff's document request and is attached to a privileged communication, the document must be produced to plaintiffs without the privileged communication, even if the only location where the document is found in defendant's possession is as an attachment to the privileged communication." Defense counsel seemed to agree with this conclusion during the conference, and also stated that when non-privileged responsive documents were found attached to privileged documents during defendant's review of documents in this case, they were withheld from disclosure with the privileged communication and identified in defendant's privilege log, but defendants did not check to see whether the non-privileged attachments had been produced elsewhere to plaintiffs. Defense counsel argued that further review of the withheld attachments is not warranted because when defendants, as a result of conferrals with plaintiffs, checked 39 of such attachments, it found that all 39 had been produced to plaintiffs elsewhere. Defense counsel argued that the sample set shows that non-privileged documents have not been withheld from production. He added, "The court does not find that defendants failed to act in good faith in reviewing documents and compiling the privilege log, but the discussion described above clearly reveals the possibility that responsive non-privileged documents have been withheld from production because they were attached to a privileged communication and were not found elsewhere in defendant's possession. Such documents should be produced. The court cannot conclude that a sample set of 39 is sufficient assurance that some responsive documents have not been withheld. As a result, defendants will be required to review all documents attached to privileged communications to determine if they're responsive, non-privileged, and have not been produced elsewhere to plaintiffs." He also dismissed defendants' contention that the issue was untimely under CMO 19, finding good cause for bringing the challenge past the 70-day time limit after production of privilege logs. So, Mary, given that a sample set of 39 documents showed that all 39 had been produced to plaintiffs elsewhere, shouldn't the plaintiffs have to demonstrate some deficiencies to force defendants to look for others?
Well, in this case, Doug, it seemed like the court was a bit surprised that the non-privileged attachments were withheld as a matter of course, and didn't feel that the 39 was a good sample. And so I think that that's why they did what they did.
Yeah, certainly. I guess you could argue that 39 sample set isn't a very large sample set. So,
although what I did not see in the opinion was how many attached documents we're talking about.
Mm-hmm.
If it was they sampled 39, they didn't sample another 60. Yeah, that 39 might well have been enough. If, this was an MDL, the numerator, denominator, whatever the number is, it's probably a lot greater than 100. So, but that would have been something I would have wanted to know.
Yeah, that would have been good to know because we have no. You would think maybe being an MDL, the number could be pretty large, but you don't know that for sure. And I think we're talking the denominator there, just to, for what it's worth. So, Tom, do you agree with Judge Campbell's decision to consider the issue, given that it wasn't within the time frame required by CMO 19.
Well, I mean, he was pretty specific about it, right? I'm quoting here now, the CMO provides that challenges may be brought later if there's good cause to conclude they could not have been made earlier, and the court finds good cause. And specifically, he went on to enumerate that, they had a practice of not checking the attachments to see if they'd been produced elsewhere, and that only had been clear to everybody pretty recently. His quote was, only recently made clear. So I think given that circumstance and the fact that there was, in his mind, good cause to go ahead and do it.
Yeah, certainly seems like you found good cause in this case. So, Judge Peck, do you agree that documents attached to privileged communications can be non-privileged? Aren't they considered an extension of that privileged communication?
In some cases, yes. In many cases, no. Not everything sent to a lawyer is privileged. We all know that. Now, if this were a work product situation, where counsel said, go find me all the invoices we had with the other party and put them all together and send them to me, that would probably one where work product privilege or protection would attach to the attachments, so to speak. But, the attachment could have been a letter to opposing counsel, could have been lots of things that are not privileged. And indeed, the party here was not arguing they were privileged. It was sort of arguing, we presumed that any of these non-privileged attachments were going to be found and produced from where they're regularly kept in the regular course of business, as opposed to the versions that were sent to counsel. Sometimes that's very easy to verify. Other times lawyers take the approach I think they did here of, we probably produced it. We're not going to spend the time verifying that. And that didn't satisfy Judge Campbell.
No, it certainly didn't. Now, what if they were hyperlink files? No, just kidding. Another can of worms. We don't
open up that
unfortunately,
one.
we're at time, so we can't get into that. So, but yes, definitely an interesting case and a good suggestion. And now to the contacts page, and we have a date for our next webinar, which is on Thursday, March 20th. So that gives you a couple of days to recover from St. Patty's Day. With that, I will say thanks to Mary, Remote Tom, and Judge Peck for their terrific insights as always, and I'll turn it back over to you, Mary.
Thanks, Doug. And we want to thank you for anchoring, and Tom O'Connor, the Honorable Judge Peck, for this insightful presentation. Our thanks to the EDRM community for your kind attention. If you really loved it, show Judge Peck, Tom O, and Doug Austin from Houston some love. Find your emojis at the bottom of your console. And to be automatically registered for on-demand webinars, click the pop-up at the conclusion. Once there, click the bell to subscribe for updates. And we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everybody.
Bye, all.